Should Mormon temples be taxed? The Church's position on that question will come as no surprise to you, but they've not always been successful in arguing for that position. Hi everyone, Nemo here, your expert on all things Mormon from a British perspective, and today we're talking about something that cuts right to the heart of the Mormon Church. Money. Money is very important to the Church of Jesus Christ of Latter-day Saints. Whether it's hiding the size and nature of investments to avoid a drop in donations from members, or whether it's fighting tooth and nail for tax exemptions, the treasure of the Church is clearly its wealth. And as Jesus teaches us,
"Lay not up for yourselves treasures upon earth, where moth and rust doth corrupt, and where thieves break through and steal. But lay up for yourselves treasures in heaven, where neither moth nor rust doth corrupt, and where thieves do not break through nor steal."
So with the modern day leadership of the Church once again ignoring the words of Jesus, let's look at the Church's history of fighting tooth and nail for their tax exemptions. Before we start though, there are some watching this, and they're generally Americans, who object to taxation in general. As a rule, they do not view it as virtuous to pay tax. Well, this video is not about the merits of taxation. Historically, the Church has gone to incredible, and in the case of the SEC settlement, sometimes illegal lengths to protect their money. That's what this video is about. And more specifically, it's about the taxation situation of the LDS temples in England, in light of the Birmingham Temple receiving planning permission in the last couple of weeks. So this all started with the construction of the LDS Temple in London. Well, actually it's 25 miles outside of London in a place called Lingfield. It was announced on the 10th of August 1953 and broke ground on the 27th of August 1955. It was dedicated in 1958. From the point at which it was dedicated, only members of the Church who passed a worthiness interview could enter. Now, of course, that makes it tricky for the Church to claim that the temple is a place of public worship and receive the associated property tax relief in the UK. It's unclear at what point the Church entered legal action to try and obtain tax-free status for the temple. I've been unable to determine whether they had the exemption and then lost it, as we'll see in Preston, or whether they applied and were denied the exemption, at which point they appealed. Regardless, by 1964, 6 years after the temple shut its doors to the general public, the case had entered the House of Lords Appeals Court. And the Church actually reported on this case in their magazine, the Millennial Star. What's interesting is if you look at the online archive of the July 1963 Millennial Star, it doesn't include the full story. But luckily for you, Peter Bleakley has a physical copy of the July 1963 Millennial Star, and so he scanned it in for me. Page 183 gives us the best summary of the decision reached by the House of Lords as reported by the Church. Furthermore, exemptions from ratings, though not necessarily consistent, showed a general pattern of intention to benefit those activities which were for the good of the general public. All religious services that opened their doors to the public might, in an age of religious tolerance, claim to perform some spiritual service to the general public. His Lordship did not find anything unreasonable in denying to the Mormon Church the public benefit of an exemption of its temple to which it would not allow the public to have access for worship, while according such exemption to its many chapels which did admit the public. The appeal should be dismissed. With that appeal dismissed, the Church settled into its position of paying property tax for its temple for almost 50 years. That is, until the Preston Temple came along in the 90s. The Preston, England Temple was announced in 1992 and broke ground in 1994. It was dedicated in June 1998, at which point public access to this building was halted, and once again only temple recommend holding members of the Church could enter it. Because of this, the temple was not eligible for the full tax exemption, as had previously been decided regarding the London Temple. But that wouldn't stop the Church from trying their luck. The fight to try and get the Preston Temple tax exempt went all the way to the European Court of Human Rights, which for brevity will be called the ECtHR. And the court documents from the ECtHR provide a useful summary of the case's facts. In 1998, the Preston Temple was listed as a building used for charitable purpose, and therefore retained a liability to pay only 20% rates, but it was refused the statutory tax exemption reserved for places of public religious worship. The valuation officer accepted that the stake centre on the same site, with its chapel, associated hall and ancillary rooms, was a place of public religious worship, which was entitled to exemption. Other buildings on the site, for example a building providing accommodation for missionaries and various ancillary buildings, were subject to full business rates. For the financial year 1999 to 2000, the applicant paid a total of £117,360 in respect of all the rateable buildings on its Preston site. On the 5th of March 2001, the applicant applied to have the temple removed from the rating list, claiming the benefit of the exemption for places of public religious worship. On the 21st of October 2004, the Lancashire Valuation Tribunal Tribunal granted the application for appeal and determined the temple to be exempt under the statutory provision. On the 14th of December 2005, the Lands Tribunal overturned that decision. The applicant's appeal to the Court of Appeal was dismissed on the 24th of November 2006. The applicant then appealed to the House of Lords. The applicant did not raise any arguments under the Convention before the Valuation Tribunal, the Lands Tribunal, or the Court of Appeal. However, with the House of Lords' permission, upon their granting leave to appeal, the applicant argued that the legislation in question was incompatible with its rights under Article 9 of the Convention and Article 1 of Protocol No. 1, both taken alone and in conjunction with Article 14. On the 30th of July 2008, the House of Lords unanimously dismissed the further appeal, holding, on the basis of an earlier judgment, that as a matter of domestic law, a place of public religious worship must be one that is open to the general public. 4 of the 5 law lords further dismissed the applicant's arguments under the Convention, holding that the liability to pay 20% business rates on the temple did not fall within the ambit of Article 9, since Mormons were still free to manifest their religion, and since the statutory requirement to be open to the public applied equally to all religious buildings, and did not target Mormons in particular. The ECtHR documents make clear that it wasn't until the church came before the House of Lords that they then tried to play a religious discrimination card, coming to the ECtHR to make a claim against the UK government under Article 34 of the Convention for the Protection of Human Rights and Fundamental Freedoms. In everything I just read, that's what the Convention referred to. And the ECtHR ruled that the decision of the House of Lords was not a breach of human rights. In fact, if you go right to the bottom of the ECtHR judgment, there is a joint concurring opinion, which I think really spells out the difference here between how religions are treated in the United States and how they're treated in Europe. The tax exemption was a privilege. It was not a right. The application of this privilege did not interfere with the exercise of the right to freedom of religion, and we therefore conclude that the facts of the case do not fall within the ambit of Article 9. We would have preferred to declare this case inadmissible. So the ECtHR pretty robustly supported the House of Lords decision in 2008, which itself was upholding the previous House of Lords decision in 1964. It's unclear to me, given no material change in the way temples operate between those times, why exactly the church thought that they could just try again to get Preston a tax exemption when the London Temple had been denied. What could possibly be different between the House of Lords decision in 1964 and 2008? Well, this is just my opinion, but I think it's got something to do with the fact that the church was far wealthier in 2008 than it was in 1964. In fact, in 1964, the church was still reeling from the massive losses of Henry D. Moyle's building program, which he had done in combination with baseball baptisms. By 1963, LDS finances were so strained that church financial officers wondered if they would be able to meet the payroll. By July 1963, Joseph Fielding Smith, president of the Quorum of the 12, was now openly criticising the spending proclivities of President Moyle, also concerning the unorthodox way in which youngsters had been baptised in the church. By contrast, in 2008, the church's wealth was well on its way to $100 billion. Now, 2008 was a rough financial time for many. According to the Wall Street Journal, the LDS Church claims that the $100 billion reserve amassed in Ensign Peak was for a rainy day like 2008. They then admitted that in 2008, the church did not dip into its reserves. But what's interesting is, due to its exposure to mortgage-backed securities, church-owned beneficial life insurance
Is your life insurance beneficial?
was bailed out in 2008.
The church had the resources to bail out beneficial life during the financial crisis, 2008, 2009.
So to the Wall Street Journal, church leaders say that they didn't dip into Ensign Peak due to the 2008 financial crisis, but to CBS they say they did dip into Ensign Peak in order to bail out their failing insurance company. Despite these contradictory statements, it's clear that the church was in a much better position financially in 2008 than they were in 1964, and I think they saw an opportunity to try and overturn the 1964 decision of the House of Lords and the 2008 decision that upheld it by trying to get the ECtHR involved and make an argument on human rights grounds. Even if it was a long shot, the church could at least afford to try and pay the expensive lawyers from Devonshire's to argue this case for them. But they failed, and both the London and Preston temples pay 20% rates to this day. And now that we have the Birmingham, England temple well underway, with planning permission being granted and demolition of the current structures to start shortly, we must ask ourselves, when the Birmingham temple is finally dedicated, it will close its doors to the public. The church will register the building as a building used for charitable purposes, and it will be liable for 20% rates. But will they stop there? Will they instead try their luck for the third time? Well, make sure you subscribe to find out.